Welcome to the Agents Angle, bringing you the inside track on the fast-moving world of the football agents. Well, that is the business side at least, whilst the governance side often seems to be playing catch-up. With me, Jonathan Booker.
And me, Peter Paleologos. As well as answering some of your questions this week, we are looking back at the latest agent exam and what seems to be another bump in the road for FFAR, this time in South America. We also look at a case of sanctions being levied against an agent and a club relating to a reportedly high-priced player in this transfer window.
And whilst you may think agent sanctions are nothing out of the ordinary, the breaches of the regulations in this case are apparently from more than 4 years ago.
All that to come on this episode of The Agent's Angle.
We're bringing you a show this week that in essence brings together a few matters that remained uncovered from the last episode of The Agent's Angle and previous episodes before that. But it's been an interesting week, thus adding more items to the in-tray for this and future shows. Not least the third sitting of FIFA's agents exam, which appears to be jubilation for many, but we plan to come back to that subject later on in this episode.
Yes, it's been a big week for many, Jonathan. We've had feedback from a considerable number of exam candidates and basically a few that have missed out or had to have a review of the exam to get the 75% pass rate. Also note that several candidates that I know didn't pass on previous occasions, the first and second exam, but did pass this time. So that's great to hear.
But to start off this episode, there were two stories we would have liked to have covered in the last episode, but time was against us. The first was news that broke just as we were coming to the end of recording the last episode regarding another glitch for FFAR, the FIFA Football Agent Regulations, this time again from South America.
Yes, we just missed out in the last episode of a major announcement. My Spanish isn't great, but this is from Argentina. On 28th of May 2024, the Civil Court of Buenos Aires decided on a request for provisional measures filed by a group of Argentinian agents. Got a couple of names here, Solomon Sabag and Martin Solomon, and others, against the FIFA Football Agents Regulations, as well as the claim against the Argentinian Football Association. And the court, on this application by these agents, ordered the suspension of several provisions of the FFAR as it was going to apply in the Argentinian market. Lucky for Google Translate, I had a look at the case. It makes things so much easier. Although I speak a little Spanish, not at the legal level, of course. So what did the court find? It basically suspended certain provisions of the Argentinian, I would say, version of the football agent regulations because they infringe rights recognized by the Argentinian constitution and also will threaten competition amongst national agents. So Argentinian agents who operate in the national space there with the big clubs, Boca, River, all the way to the smaller clubs, Platense, I can go on. FIFA is ordered, as well as the Argentinian Federation, to suspend several articles, and I'll mention them, 4, 5, 6, 12, 13, 16, and 17 of the FFAR, and the Asociación de Fútbol Argentina, the Argentinian Football Federation, is ordered to refrain from applying them in its own national football regulations. Jonathan, the interesting thing about this is, and we know from previous cases, that the German courts, in particular the Dortmund case and the Dusseldorf case, we've had Michael Frank on the show previously, had a podcast, and he's mentioned about those cases, suspended 9 provisions. The Argentinian court suspended 7 provisions of the FFAR. But what provision was not suspended by the Argentinian courts? Articles 14 and 15. And what are they? The service fee caps. So in Argentina, a strong decision by the court against the FFAR, but it does not apply to the service fee caps, Jonathan.
A huge footballing market, especially in terms of the exported talent, and one we have to note more than likely won't be influenced that much, if at all, by the ECJ, the European Court of Justice, and their ruling on which FIFA seems to be pinning its remaining hopes over FFAR. But on the matter of agent regulations, another subject we wanted to cover previously, but it did have so many angles from an agent's perspective, didn't want to rush it and miss out on many important aspects there were to consider. And despite there being quite a few agent-related disciplinary cases that we could look at, this one really caught our attention, as despite this being an agent matter from some 4 or 5 years ago, it seems only recently it has been acted on by the football authorities and come to light in the last month or so, with a sanction against an agent, a club, and club officials on breaches of intermediary regulations, as they were at the time in England. Another interesting aspect is that the player in question wasn't as high profile at the time of the alleged breaches of the regulations as he is now, and he has prompted quite a lot of transfer speculation for this transfer window, having been linked with many clubs in recent months, including Manchester United, Liverpool, Aston Villa, PSG, and Chelsea. Probably because of some of the fantastic performances he's put in the Premier League in recent times. And with that in mind, I have to ask if this disciplinary case would have received as much attention had it not been for the current profile of the player in question.
Yes, Jonathan, this is a case involving Michael Olisse's agent. So Michael Olisse being the player. Michael Olisse's agent was handed a 6-month ban over an agreement with Reading. Now, we're talking about Olisse, who's a Crystal Palace winger, has had a great end of the season of the Premier League. He's in demand this window. There's a lot of speculation, as you mentioned. Basically, this matter is an old matter, probably back in 2019. So we're looking 5 years ago. The agent of Olisse was banned by the Football Association following investigation into a contract agreed with the player's former club. A very unusual case because we don't see many disciplinary actions on agents and clubs. It was basically, I would say, an alleged illegal financial agreement between the club and the agent. The agent, who is he? Glenn Twenebow, who was a registered intermediary at the time, and he is also, I believe, now acting on behalf of Crystal Palace in terms of the transfer of Olisse. I had a look at the football directory, the football agent directory, Jonathan. It is still down. I haven't checked if Glenn Twenebow is an FFAR agent. I'm assuming he is. But this is a very interesting case, and we'll go through the reasons and our observations of this case because in not only FX agents, this one's affecting clubs.
And I have actually just checked the FIFA agents platform for the agents register, and it is still offline and under maintenance. But I've also checked the FA's registered football agent list, and the latest list there for the 31st of May 2024, we're recording on the 11th of June here, does list Glenn Twenebow on that list, and seeing as there's a prerequisite that FA registered agents are also registered with FIFA under the FFAR, I think it's safe to say that he is registered with them at the moment. But before I start on the FA with this one and some related matters from personal experience, and hello to the FA, as we know some FA agent officials are fans of the agents angle and listen in, we aren't going to debate the rights and wrongs of receiving a percentage of a transfer fee or a commission related to a future transfer fee, as it's a complex and hugely debatable issue. But it is something we have discussed as a possibility for a future episode. Likewise, we aren't going to look to delve into the finer detail of this particular case and the FA Regulatory Commission's releases and findings, as we could be here for some time if we did that. Plus, there are a lot of redacted specifics in the documents released by the FA that make such scrutiny of timelines and the parties involved quite difficult. But I have a couple of basic questions regarding this case, which I don't know if you can answer, Peter, from a legal and investigatory perspective. Firstly, why has it taken so long for the investigation and subsequent hearing, and what actually triggered it? Not just because, one, the breach was seemingly in 2019, some 4 or 5 years ago. 2, the player left the club in question in July 2021, so 3 years ago on that. 3, briefly reviewing the notes, reports and findings, it appears the agent was the one who inadvertently highlighted the breach to the FA. So in effect, the agent reported it themselves. 4, when did the FA start the investigation? 5, when did the FA start proceedings? I think it's also worth noting that no payment in terms of this clause, which was deemed to be a breach, was ever made. And yes, I get the point of seeming intent in putting the clause in there, But there is also an element of self-reporting here to be considered as well in the case. And at the point that the matter was identified by the FA, was an opportunity made to the agents and the club in question to rectify the matter, as I understand should arguably be the case. Subsequently, and fast forward into the current time, I think it's safe to presume the FA has already reviewed whatever documents and agreements may exist between the agent and the player's current club, Crystal Palace, and that is all clear. Because otherwise, there could well be another charge and set of sanctions in the pipeline.
Jonathan, as you know, I can't and I won't provide any legal advice ever because we're not a legal advice podcast. We just give general observations. I've been asked several times by fellow agents, some also quite naive, about can I make a claim on the transfer fee? It's a policy issue. It's a very technical breach. We know FIFA banned TPO and TPI, third-party ownership, third-party investment, third-party interest, whatever you want to call it, and related economic rights, including ones that are claimed by agents. Now, with your questions, you're right. The breach was seemingly in 2019, some 4 to 5 years ago. I think in this case, the FA may have taken a lot of time. This is serious conduct. Agents are not supposed to be involved in a percentage of a transfer fee or a commission related to a transfer fee. A lot of these investigations do take a long time. Why? Because they're complex. You need to have a thorough investigation because it may be not all available in the paperwork. You may need WhatsApp messages. You may need parties to give you information. A potential brief of evidence that meets certain points of proof could take a year or two to compile, from my investigative experience, from my legal experience. So that's why maybe it's taken so long. Now, reading the notes and the reports and finding appears that, yes, this was a self-reporting by the agent. And very important, I think with self-reporting, there should be at least mitigation. What I mean by mitigation, someone puts up their hand that they did something wrong, that should definitely be taken into account. But I'm also surprised that no club or agent lawyer picked up that these are economic rights to avoid damage to the agent or to Reading. This is clear cut. This has been clear cut from, I would say, from the West Ham days. West Ham had that issue with third-party ownership, if you recall, Jonathan. I think it related to Tevez and another player, Mascherano. Everyone's on notice about what agents can do in relation to players and whether they can hold economic rights or claim part of the transfer fee. Now, there's another thing, Jonathan. I don't believe the Football Association, when it issues charges, they're time barred. If you remember UEFA, they also took some action against Manchester City, but some of those charges, if I can call it, were time barred. When I mean by time barred, you've got to bring an action within, say, 3 or 5 years. I don't think the FA has that limitation. So they can bring charges that happened between March and July of 2019, which were misconduct charges for breaches of FA Rule E1.2 against Reading and 4 other individuals. And I'll just end on this. In Reading's point of view, it was 3 of their officials acting on behalf of the club, as well as the agent or intermediary who basically negotiated an interest in a registration right or economic right. So that is a clear breach of the FA's intermediary regulations at the time, would be a clear breach under the FFAR. So the matter had to take place, Jonathan.
Personally, I think there's a lot of naivety here, both from the agents and the club involved. But that said, this is nothing new regarding some clubs, as from my experience, many club officials have been ill-informed on agent and intermediary regulations for many years. Some are better than others, especially when they have an in-house legal team. But not all clubs have that luxury, and club secretaries in particular have a huge amount of roles and duties to fulfill at so many so-called smaller clubs that agent regulations aren't always a priority for them when compared to other regulatory matters. But going back to the agent, as this is the Agents Angle podcast and not the Club Angle podcast after all, the sanction in terms of the fine is neither here nor there for me. Whether or not it is proportionate is debatable. Arguably it is, given the player's status at the time of the breach, but I haven't looked at all the EPPP calculations and training compensation to make that judgment, and predicting a future transfer fee is more luck than anything. However, the suspension of the agent is quite interesting, as the FA Regulatory Commission does seem to have been thoughtful in terms of the agent's ability to operate in the impending summer transfer window, as the suspension doesn't seem to start until later this year in October. However, that does put the agent and his clients in an interesting predicament, not just in the winter or mid-season window when the agent is suspended, but also indirectly in this impending summer window. Because in the mid-season window, could the vultures start circling around his clients? That's if they haven't already. And how will he operate during that time? As arguably, whilst his representation agreements with clients could endure during a suspension, they could well be challenged. As I would argue, it is likely that technically he can't uphold a lot of his duties as an agent as part of the representation agreement with the client, if we take it into consideration that many representation agreements are pretty standard for a lot of agents. Could a subcontracting caveat be in the representation agreements to allow a colleague or agent associate to step in to cover the agent's activity whilst he's suspended? And there are many questions related to this. But the big thing for me is how this suspension impacts in respect to the player referenced in terms of the breach, Michael Elise. And we have to stress that the player is in no way implicated in any wrongdoing in this matter from the Regulatory Commission's findings. Understandably, he is highly coveted by a lot of clubs at the moment and a lot of reported interest in this summer window from big clubs. So possibly it means, amongst other things, one, the agent rushing to get something done in this window before the suspension. Two, does the agent in that situation rushing possible transfer weaken the agent's bargaining position in the summer and that of the player? And three, could other parties actually obstruct a move this summer for them to benefit in the winter or beyond when the agent is suspended or the representation of the player by the agent has actually ended?
Jonathan, they're all good observations. It's interesting you've got that tension here where we know that going forward, all our agreements are a maximum 2 years with players. So agreements do run out quickly. Secondly, you have an agent who's suspended probably during part of the agreement. You're going to rely on the player's goodwill here to stay with the agent, especially if he can't act for a certain period of time. We know that Reading, they've been fined £200,000 for their part in the breach. And I just want to go through intermediary Glenn Twinnebay, who should be an agent now. He did deny all the charges, a word foul proven. He was fined £15,000 and suspended for 6 months from all football and football-related activity, including, and this is important, football agent services and intermediary services. I want to focus, this is the agent's angle, on Twinnebow's ban on the 4th of October. So that is after the window, meaning he can still work this summer for the player, this window. Agency is a relationship game. If Elise's and Twinnebow's relationship is strong, then the potential for a move and getting a deal, the focus will be this summer window. I've not seen, obviously, the player contract, but most player contracts, especially the ones that would have been signed for the FFAR, would allow Elise to have grounds to terminate, maybe because of suspension or, as you mentioned, Jonathan, the duties of the agent cannot be fulfilled. And I would think that Elise, if that was in the contract, would have grounds for that. The interesting question regarding obstruction from other agents, that all comes down to the demand for the player. What's Crystal Palace's position? Do they hold some leverage here? Are the top player agencies and agents with track records hovering? So a lot of factors at play. Let's see what happens.
Now, Reading is one of those clubs who have suffered quite a lot of financial difficulties in recent times. Maybe self-inflicted, some may argue, but that's probably more one for Kevin and Kieran on the Price of Football podcast than us. But their fans have had a huge amount of uncertainty, and for me that isn't fair, despite Reading being a bogey team for my club, as they always seem to beat us when they meet. Do I feel for the agent on this one? Not particularly. In my view, they should have known the broader restrictions of the regulations, and arguably known that better than some of the club officials involved. After all, as I said, we've all been there at times where in discussions with club officials, it becomes apparent that we know, as agents, more on agent regulations than they do. And that's understandable because it's our job after all. It is worth noting that this isn't the first time this agent has been ambivalent to agent regulations and been sanctioned in the past, and that was arguably on a far simpler and some may say a very basic regulation that caught quite a few ill-informed intermediaries out in England since 2015. Did the ambiguous nature of the regulations let the agent down? In a way, I think yes, they did, as they let everyone down at times, whether agents, clubs or players. But then it is our duty as agents to seek clarification, whether from a specialist lawyer or the relevant football authorities. I do have some sympathy for the club and club officials, but then again, they could have sought external legal advice or clarification from the FA. And whilst it could be considered a bit of whataboutery by the club, Reading actually mentioned the matter of inconsistencies in terms of the regulations and sanctions in one of their statements about the case when referencing another club. And I quote, "The club views these sanctions as excessive, in particular when considered in comparison to sanctions handed down in a previous case which involved another professional football club and multiple breaches of the FA's intermediary regulations over a 10-year period." And as a side note from me, it's going to be pretty difficult to breach the FA intermediary regulations over a 10-year period, as they only technically lasted just shy of 9 years. But on that, I do agree with the club on the matter of clarity and inconsistency. And that is not just with the FA and agent regulations, but it's apparent to me with FFAR and other football regulations. Plus, I'm confident there's a hell of a lot more cases like this that the FA and other football authorities have possibly missed, or dare I say, neglected, and likely have the evidence to hand, or it can be easily obtained. But the big question of the timeline in this case is also referenced by the club in their statement. And again, I quote, "The FA commenced its investigations a considerable amount of time after the conduct in question, and the disciplinary charges were issued 2 years later. Now, some 5 years later, the matter has finally been heard and a decision issued." And I think a lot of people will agree with that frustration and have some sympathy for those involved, whether it was a naive and innocent mistake with the breach of the regulations or an intentional one.
Look, I would be frustrated because it is a long period of time. We know cases do drag out, and Reading in a very difficult position, as you said. I'm sympathetic with that. And there must be more matters like this that have been overlooked. Some people will argue, is there been consistency with this? However, this is a very serious policy breach, and every agent and clubs should know that the agent should have not part of that fee. And the FA, it might be optics, but I think it's enforcement. It's a clear-cut case. Has to put its foot down. Now, for me, it's a big error of judgment here. Glenn Twenebow, he entered into agreement to make himself eligible for 10% cut of Elise's future transfer fee. This is totally prohibited by FA rules. It did take a long time, but it's a very serious breach. Now, an interesting fact here, Jonathan, no payment was ever made. This suspension and the penalties also against Reading were made on the intention or the knowledge that this was an agreement that had to be fulfilled, but no payment was ever made. So that should have been a factor that probably limited his suspension, or there was no need for restitution. But we all know even now the FFAR is also putting responsibilities on clubs as well as players and agents to understand the regulation and what everybody's entitled to in terms of who they represent, and doesn't allow obviously economic rights and these type of arrangements. So it's disappointing for Twenebow, it's disappointing for Reading, but this is a clear-cut case and the FA had to act, Jonathan.
Now, you know, Peter, as we've discussed the matter privately, some of the aspects in this case I can personally relate to. And I keep coming back to this amazingly lengthy timeline on the case, from the time of the initial breach to the investigation, then the hearing, and ultimately the sanctions. When ultimately, to me, and I get what you say about the investigation process and so on and so forth, this seems a straightforward breach on a document lodged with the FA and thus ultimately a confession of a breach. It hardly seems to warrant Sherlock Holmes and Perry Mason to close the case. But am I surprised? Absolutely not. And I would go as far to say that this is an example of the FA in England, again, being asleep at the wheel when it comes to agent regulations. And in some ways, for me, with the resources they have available to them compared to other national associations, they've been sleeping since 2014, when FIFA announced the scrapping of agent regulations and the licence as it was. As you know, I have a few issues with the FA going back several years now, whereby I have on occasions made very simple requests, such as confirmation of communications and also clarification of regulations, which they have on occasions repeatedly delayed, sidestepped, and avoided giving an answer. And I'm not alone in that, and I'm confident in saying that. And on some of those aspects, it goes back not 4 or 5 years, as in this case, but possibly 6, 7, or 8 years, or maybe even more, But I did note one direct correlation to this Reading case to one experience I have had with the FA, whereby it is referenced that the FA sought to clarify the regulations with an amendment, which I believe to be primarily Regulation E5. And the reason why I specifically remember that is that I asked a question in relation to that exact topic of someone at the FA's agent department and never got a clear response. In fact, at times ignored for a lengthy period, which I recall may have been some 6 to 9 months at one point, which I take on reflection now as me possibly identifying a loophole they didn't want to admit to. And here we are back to the subject of inadequate communication, consultation, and engagement between agents and the football authorities. And for those who are wondering, I did eventually get a reply from the FA on that query. And how was that achieved? I emailed the chief exec of the FA, the head honcho, and I got an answer from the original person thought to be dealing with the matter within a couple of hours. Something I shouldn't have to do, and more importantly, should not need the chief exec of a National Football Association to step in and effectively crack the whip to prompt somebody to make a simple response as part of their job. And lo and behold, this regulation, which I refer to in this case and what I queried, was subsequently amended, which I say is closing the loophole, but they refer to term it as adding clarification. It is important to note, however, that ambiguity and unclear agent regulations is not only here in FA regulations, but as I mentioned earlier, it could be argued it is also very evident in the FFAR as that stands.
Agents and their lawyers are always looking for loopholes in any regulatory framework in terms of operating their business. But I understand your concerns, Jonathan, and communication is important. You're vigilant enough to pursue clarification in this matter. Some people don't do that. We all want, on a general level, that FAs answer agent queries. It always depends on the FA and its relationship with agents or agent associations, how responsive they are or how quick the communication is. But I think most FAs at the end of the day will give some clarity, but it's a case-by-case basis. However, I'm going to disagree with you slightly with the FA. I think the FA, the English Football Association, is similar to the French FA or the FFF. It actually investigates and issues penalties. We've seen that on their platform, which outlines a lot of agent matters being heard and penalties invoked, including license suspensions. I don't see that in many other national FAs showing who's been suspended. And we don't see this in a lot of countries, Jonathan. This is quite detailed and it sets a precedent of other matters because, as I mentioned earlier, the FFAR talks about responsibility of players and clubs and not just agents in breaches of agent agreements or any misconduct therein.
I think it's important to stress that the Independent Regulatory Commission is separate to the actual FA who did the investigation and brought the case and heard technically the confession on behalf of the agents involved. And I think we're going to agree to disagree on some of it. But I'll come back and be quite blunt that this all centres around an agreement that was signed by the agents, by somebody representing the club, and logged on the FA system, as it should be, some 5 years ago. They had the evidence there and to hand, and the Regulatory Commission can only work on the evidence that's presented to them. I've got no problem with that whatsoever. It's the process that got them there. But going back to something you actually mentioned there, Peter, we both know an intuitive and professional legal mind can spin the wording of a contract or an agreement to comply with the regulations, even if subjectively breaching the original aims and intentions of any such restrictions or regulations. And that's nothing new. We'll both admit that that is absolutely nothing new in this industry. Then it's a case of the football authorities effectively playing catch up and closing such loopholes, even if it's after the event. As even pre-2015, agents, agencies, and their lawyers were creative in ways of wording contracts and agreements that allowed them to receive part of a transfer fee or sell on, such as not referencing a percentage to the transfer fee, but equating the commissions to scales, for example. So arguably, the football authorities should be more concerned about the techniques used to circumvent these regulations in exploiting players, for example, not someone who, out of what seems to be ignorance or naivety, seemingly breaching the regulations and then in effect admitting guilt and reporting the offence. In fact, the football authorities, for me, should have for a long time now be encouraging agents to work in cooperation and not alienate them. And that, in effect, may go some way to address this hidden information problem, as FIFA repeatedly refer to in their pleadings in regards to FFAR.
There's two aspects here, Jonathan. Firstly, you mentioned the federations. They're always playing catch up. That's why a lot of times you get commentary on the regulations. That comes sometimes after the fact the regulations have been implemented, whether that's FIFA or even the FA or decisions that are made by FIFA's dispute resolution chamber or the Court of Arbitration of Sport. So there's always playing catch up and they need to clarify what the regulations mean. Now, regarding the agents aspect in the loopholes you mentioned, there is just too much competition. Many agents and their lawyers have to be creative to get quick deals done. As clients, we know, especially at the top end, clients are impatient to get a deal done or get an employment contract. The other thing is agents don't reveal their IP or intellectual property, I should say, or their strategies for transfer windows. So regulators don't always get an opportunity to understand fully the business. And as I said, and you've said, they're always playing catch up. Good agents do get good lawyers to check across all things. Now, going forward, especially under the FFAR, there's a recognition of agents not interfering with other agents' contracts. And that's very important for me. I think that's one of the things of FFAR where during the 2 years, or take away the last 2 months, if you've got an exclusive agreement, another agent cannot interfere with your player. But what happens when clubs or players decide to change or isolate the agent? This is why it makes things very difficult. Now, I would have liked to see the agent tribunal. I think this is where the agent tribunal could have played a role to see principles like this. You know, we talked about a transfer fee for an agent. The agents chamber or agents tribunal that FIFA was setting up and has set up, but it seems like it's suspended at the moment, would have been a very good education piece for agents because if matters were taken there, they can deal with a lot of these things on a worldwide level. Now, I think that everyone's got a role to play here, and it's not just the agents, and not just the FAs, but the PFA, the League Managers Association, the agent associations, all need to inform their stakeholders, their members, their clients, their public, what's going on with the agent space to understand and clarify what can be done and what can't be done. It can't just be left to solely FIFA or some lawyers. And I think that's the learning here. And going back to the case, Reading and even the intermediary, a lack of information, knowing what's right and what's wrong, we ended up with these penalties.
So, with that case to one side, and I hope those listening appreciate how important an example of a disciplinary matter relating to agents or intermediary activity it is, and the reasoning as to why we took an extended period of time to focus on it. It wasn't solely from a regulatory perspective, but also from a view of protecting agents, clubs, and players in how they undertake agent related duties, and the need to be aware of such ambiguities in the likes of the regulations, and also to seek professional advice when required or just on the occasions when we're not 100% clear. But we all have questions and areas of uncertainty when it comes to the football agency world, and it doesn't matter how experienced you are as an agent or your background. Anyone who claims to know it all is, in my mind, either lying or deluded, as it is a global industry with a lot of variations and nuances, with many aspects changing all the time. Hence, we have guests on the agent's angle to look at specifics that aren't necessarily specialist areas for us.
I agree. We're always learning in the agent business. You know, we had intermediaries before, we had that framework, we had a pre-licensing before 2015, we've had now FFAR. It's a learning curve, and also in terms of the business trends that are happening in the market. Agency is always evolving. It's, you know, changing dynamics because there is an intersection here. Global business, global deals, national business, national cultures. And right now, we've also got an entry of a lot of new participants in the agents market. And then when you look at a lot of club philosophies, there's been a huge change in player data, analytics. And then we have the emergence of the mega multi-agencies we've discussed before, and we may raise a little bit later again. So many things happening, and it's always evolving, always changing, Jonathan.
As such, we've had quite a few questions sent in over the weeks, and we're going to make an attempt now to offer our view and or answer some in the hope it may help some people. We have selected 4 questions for now due to time, but please keep them coming and we will do our best to answer others in the future. The first question is from Tanish, and the question relates to how to find out if a player is in the last 2 months of his rep agreement with his current agent, making it viable for other agents to approach him. So an easy one to start with a clear and straightforward answer, Peter. Best of luck with that one.
Nothing's easy in this business. There is actually no real database available for this or any source. I mean, obviously, you can always check Transfermarkt, which sometimes identify agents, but that's not always reliable. They can be very out of date. I think it's practical approach of how you would deal with finding someone if in the last 2 months of their contract. So you've got 2 years, and the way the FFAR works, another agent can approach in the last 2 months to ask the player to join their agency without breaching any regulations. Basically, it would be, I would ask the player, and if the player wants, with the player's permission, approach the agent. Some agents may also ask the club, but you have to be careful as that's not always transparent, and that can also result in a breach. But also, there's no one answer. I would ask around the network if they know the agent, and also any players who know the player in a respectful way to find out their agent. A very simple question. A player you know may ask this player that you're interested in, do you have an agent? Not do you want to change the agent, just do you have an agent, and try to source that. Also, scouts are very important here. They have a lot of details of players. You can always ask scouts to give you player details. And if a player says they do have an agent, then you can contact the agent directly. Remember, we also work as brokers. So that can also work where you can sort of scope the agent and say, look, I've got some deals for this player. Do you want to work together? That's another way around not breaching the 2 months. But the only way to find out is just ask the straightforward questions in a respectful way to the player or maybe to someone close to the player. And when you do find that information, and say, for instance, they're only 1 year into their contract, then you must go to their agent and start a discussion there. That would be the best approach and advice or tip that I would give.
This is an area that when I first got into the industry, I used to tread on eggshells of not breaching another person's exclusive rep agreement, maybe out of naivety. And it's the question we've all been asking for years, isn't it? And technically, for me, you don't know if you don't ask either the player or a friendly club source. Much like if you don't know the age of a player and the danger there is that some 14 or 15-year-olds who, as minors, can look 18 or 19. Personally, in my time as an agent, I came to work on the principle that when you first approach a player, you aren't doing it with a view to immediately entering into an agreement or encouraging them to breach their representation agreement with another agent. So it is fine for me if it's done in the correct manner. The problem is that a lot of people do it with the intention of poaching player clients from other agents, and that's the crucial issue. Otherwise, on this question from Tanish, it is a question that a lot of people ask, and a very valid one. The next question from Alexei on a matter that I believe is still very current when it comes to the disputes on FFAR, and thus still very unclear, and we have been asked it in various ways on quite a few occasions now, both on the show and individually. And I'm hoping we will get some clarity on this specific area after the ECJ ruling on FFAR. And the question comes from, can an agent put a paragraph about fines, penalties for exclusivity violation from the player side in a rep agreement or contract? Now, as I said, this is a huge area of confusion with FFAR, and I heard it referenced at the CAS hearing between ProFA and FIFA, and for me at that time, it looked like FIFA just didn't get it in terms of the agent's concerns and the practicalities it brings from the agency world, and seemingly they still don't.
I assume Alexi here is referring to the agent's contract with the player. We know from previous episode, we discussed protected periods and what can happen if someone breaches a contract in relation to a club contract with a player. But our focus here is the agent contract. And I get asked this all the time. What if the player leaves? Can I get paid? Or can I have a clause in there? If they leave, there are some damages or some penalty paid to me because I've done all this work. And it really hurts my business when they just walk away and there's no penalty. Now, this is a bit of a complex matter and depends which jurisdiction you're in. There was a case, a lawyer by the name of David Winnie from Mayfair, a solicitor. He acted on behalf of Chilean international, Guillermo Maripan, who plays for Deportivo Alavés, a Spanish La Liga club at the time, concerning a breach of contract. And what it was an Italian football agent based in England had claimed that the Chilean player Maripan breached the terms of a representation contract between the two parties. The agent sought to rely on a liquidated damages clause, which is similar to a penalty in the representation contract, which obliged the player to pay a fixed sum or percentage of a player's gross income in the event of the breach of this exclusivity clause. The agent sought to issue proceedings in the High Court in England, asking for six-figure sum in hundreds of thousands in damages. Now, Mr. Winnie, the lawyer, the player, resisted these claims on behalf of the player. So in this case, I would say English courts will look at this penalty for employment or this scenario dimly, very hard to enforce. Now, to caveat this, it depends on the country. Swiss law, as we know with the club contracts, may allow a penalty clause if it's agreed between the parties. Swiss law, and that's where the Court of Arbitration is sports based, FIFA is still based there, they may see things differently. Whereas Commonwealth type countries like England or Australia, where the labour laws may be different, may not allow courts or tribunals or regulators may not allow a penalty. So depending on the jurisdiction you're in, I would go to a local lawyer, and maybe more so on the employment law side, and look at whether a penalty clause, can be put in a contract. Because we do know, and I'll go back to the FFAR, that you cannot put a clause in a rep agreement that limits a player or a coach to autonomously negotiate or conclude their own employment contract without the involvement of a football agent. So any clause is null and void. So the FFAR looks at that aspect, but doesn't look at the full penalty of exclusivity, I would say. I would also preface this that a lot of countries have got very strong player unions, FFPro members, who will always strongly resist agents penalising players with clauses, especially penalty clauses, Jonathan.
It's not actually helped in all of this that this is a key part of some of the objections to the FFAR and some of the hearings and injunctions that are going on. I know it was part of the Profa case. But I take it that in a best case scenario, this is a matter of crossed wires between what FIFA wants and what the agents want. And as I said, FIFA just not getting it from a practicality point of view. Or at worst, are they inadvertently punishing agents and being particularly difficult in allowing a client to effectively dump an agent without justification? Now, you know, Peter, I have quite strong views on ethics and values in the agents world, and I don't believe there should be any penalty clauses in a rep agreement between agents and clients, unless there is a clear breach of the agreement and it's fair reparations, as it would be in a lot of business contracts. In my view, an agent being paid what they are due, as per the original agreement for services provided, is not a penalty clause, such as the player choosing to represent themselves in final negotiations. And likewise, a player should be free to choose not to use their agent at a particular time, however ill-advised it might be.
Yes, it very much depends on the circumstances. I think if an agent found a club and started negotiations and did a lot of work, and they can prove that through emails, WhatsApp, and they've got a representation agreement in place, then all of a sudden the player gets the deal through other means and the agent misses out on a commission. It's very likely that they can make a claim and get part of the fee owed in some sort of litigation. Now, this is why it's so important, especially in the international scale, that we need the agents chamber. That's where agents can claim for work done. And then we have cases just like they have on Just Cause, where we talk about Just Cause being a major area in terms of the FIFA jurisprudence, the Dispute Resolution Chamber and CAS. The same thing would happen here. So you would have cases that inform the agents and everybody that this is acceptable and this is not acceptable. And that gives guidance to agents and say, okay, if I get a deal and get close to it and do work, I'm sure if I make a claim, I'll get part of my fee. Because you're right, a lot of agents do a lot of work and it's unpaid. And the player can move under this sort of FFR. Hasn't been tested. And we know the FFAR, a lot of regulations, including a player doing your own deal and whether an agent can claim something for that under exclusivity, nothing's been tested. So I think that's where it all lies. But it goes back to my point. Depending on the country, depending on the clauses, it's really a case-by-case basis right now.
I think the best advice, Tanish, is to find yourself a good football lawyer. You might find ones around about Melbourne in Australia. The next question is what seems to be an experienced agent's intermediary. And Tomo asked, on losing the agent license due to the introduction of intermediaries, I became an intermediary for about 12 months, then surrendered it. I've heard if you had an original license, i.e. passed the pre-2015 exam, you could get this back. Now, on this one, Peter, if I may, I think it may well be bad news for Tomo and people in the same boat, as it's my understanding that the window for legacy agents has now passed, and they will now have to sit the exam and go through exactly the same process as any other applicant for the FIFA football agent's license. I think the window FIFA allowed for legacy applications was pretty reasonable, but there are many who gave up on the industry since 2015 and RWWI, and hence are a bit out of the loop, as sadly it seems to be in this case.
Yes, I totally agree with you, Jonathan. There was a deadline for applying for a legacy license and to transition to the FFA license without sitting the exam. You needed to show proof, and a lot of that proof and paperwork came through your national association. So the legacy pass has now ended. You have to sit the exam. Of course, one little caveat, if you're an Italian or French agent, when those national frameworks are finally recognized by FIFA or cross-recognized between the French and Italian federations and FIFA, you may be able to get a recognition or license that way without an exam. That might be the exception going forward, but for everyone else, if you didn't get your legacy license or legacy pathway last year, I would say, you have to sit the exam going forward.
However, and please don't hold me this to anyone, I have heard of cases whereby FIFA have granted legacy agent status after the date the applicable window was supposed to end, but is my understanding that was in exceptional circumstances and reviewed on a case-by-case basis by FIFA. So it may be worth pleading your case and keeping your fingers crossed in those cases. And the final question, well, for now anyway, is related to RSTP, Regulation on Status and Transfer of Players, which is very much an area you keep abreast of. This one is from Rendo, who asks, understanding RSTP and FFAR regulations to a good level, but more importantly, knowing how to apply them when discussing with clubs, understanding how the rules can work in your favour as an agent. So do you want to give a quick summary of the key points, as RSTP is an incredibly in-depth area?
The RSTP was part of the exam material, so agents, of course, needed to be across it, as it's one of the key tools or documents which we use, especially for international deals as agents for players. It's been around for years, so past and present agents are always dealing with the RSTP. My approach and suggestion is very, I would say, practical to understand how to apply this in a negotiation, the RSTP, but also the FFAR, because there's an interrelationship. I would prepare a separate checklist for both. Very simple checklist. It's a way to guide you when negotiating with clients and clubs. For RSTP, I would set out all the key clauses that a contract or a transfer agreement are covered in that RSTP rules. But also, if you're dealing with, say, the MLS, Major League Soccer, or the A-League in Australia, there's the collective bargaining agreements, which also affect contracts. There's also clubs use standard federation contracts. A lot of national federations have got standard contracts. So all these are part of understanding the RSTP. Now, what I would do is a checklist where I set out like a schedule, put your bonuses, your transfer clauses, explain what they are, put what just cause is, so which is part of the RSTP, how contracts is terminated. So then you can look at the clause in the contract. If there's minors, what are the regulations there? Understand the maximum length of a contract and protected periods. Is it a 2-year or 3-year protected period? Is it a loan? How's that going to work? Which club's going to pay? Overdue payables. So when you set out, say it takes 2 months, 3 months, no salary, then you know you need to go to the overdue payables procedure, which is fundamental in the RSTP. Be aware of the special provisions for female players. There's quite a few there. There's provisions for coaches. There's trials as well. When a player goes on trial, now the RSTP deals with trials, especially internationally. Also, registration periods. Understand the window. So you have this checklist for RSTP when negotiating the contract to make sure you tick up all the major substantive issues that you're representing the player on, and use that to guide your negotiation and don't miss important elements. For FFAR, you have a separate checklist when you're dealing obviously with players or a club. Exclusivity, the period of the contract, what the fee is, probably the most important clause, scope of services, what football service are you providing, termination, jurisdiction, and alternative dispute resolution. Very important now that the agents chamber is not in effect. Where would you go without a dispute? What about working with other agents, mandates, communicating with players? Who communicates? And then obviously the obligations of both your clients and yourself. So I would have checklists, an RSTP one for the contract negotiation, and your FFAR one. That's the only way you're able to run a good negotiation. Obviously, as you get experience, it becomes second nature. If you're not too sure, experienced agents or a football lawyer can assist with that.
And of course, be careful when you're representing the player that you don't put in 10% of the transfer fee. So, folks, we did eventually get round to answering some of your questions, and we will do more as and when time allows on future episodes, all being well. But it is great to have people asking questions, if only to seek clarification, whether they're an experienced legacy agent, a newly licensed agent, someone considering taking the agent's exam. And on the topic of the exam, the results from the third sitting of the FIFA Football Agents exam came out a few weeks ago, and a picture is starting to form as more details seep out, or more accurately, drip out.
Yes, I think it's more of a drip feed at the moment regarding pass rates. I did get some feedback, Jonathan, that quite a few people passed the exam. That's probably anecdotal, but quite a few people I know who just took the exam the first time did pass. Also, several people had their exam corrected by FIFA again and passed after a process. They may have got 14. Two people I know got 14. There was a couple of questions that weren't possibly marked correctly, and they actually passed. So that's some of the feedback I'm getting. I think we'll just have to wait for the wash up until some official announcements are made. But it's a bit like the first and second. There's always something going on. But I think in terms of this exam, I get a more positive vibe that quite a few candidates did get through, Jonathan.
I think it's interesting to hear the feedback from this third sitting of the FFAR exam, as we've heard it from the previous sittings as well, and it's changed a bit. But it seems with this one, this third exam, there is a format change with a scrolling page, as I understand it, with all the questions on there that has addressed some of the technical issues from the first two exams, where people had to click forward on a page and there was IT issues. And also, there is a reportedly relaxing of the rules on the use of mobile phones and revision notes in some of the exam locations. But as you said, there have been some saying they thought the exam was easier this time around. But for me, that's an incredibly subjective statement. As one, you aren't going to hear it from those who failed. Two, the exam is still randomly generated, as we understand. So some will get arguably tougher questions than others. And three, what is tough to one candidate may not be tough to another candidate and vice versa. So it will be interesting to see the pass rates as and when FIFA decide to release them for the third sitting. They may have to spin those numbers first, of course, and they may not openly release them anytime soon, as the pass rates for the second exam were released by FIFA somewhat covertly and without fanfare, unlike the first one. The other thing to note is that all those people who didn't manage to pass at the first or second sitting of this exam, but then passed at the third, consider yourselves very fortunate. As with the old agents exam, pre-2015, if you failed twice, you were not allowed to resit the exam for a set period.
You take me back, Jonathan, reflecting on we both took the pre-2015 exam way before 2015.
We sound like two old farts now, don't we?
Not so much, but yes, we did take the pre-2015 exams, which were closed book and also included national regulations, which is very different to the FFAR. And I recall back then we didn't have this. FIFA has published a lot of guidance material and how it all works and how to take the exam. And I recall as well, and I don't want to sign negative or anything, but sometimes pre-2015 exams, one or two or three people passed. And as you said, you could only take it 2 times in a row, then you were suspended for a period. So it was a different scenario back then.
Yeah, I think the pass rate in England over the period of time was something between 6% and 15 or 16%. So it was a different scenario. And on the point of the revision material, that's something that gets overlooked. And I do think FIFA deserve credit for that. We had to go and seek out the revision materials in the past and make sure you got the right version of them. Whereas FIFA this time around have bundled up all the revision materials for candidates. But there is one quite concerning set of reports we have heard about, and you alluded to it previously. And that is a number of cases whereby candidates have had a question or questions, and the answers have been marked as incorrect when their answers are in fact correct. And as one question on this exam counts for 5% of the total mark, some have reportedly failed because of this. Now, we are trying to get to the bottom of this, and information is very thin on the ground. FIFA tend not to answer such questions, and they aren't going to publicly announce such problems. And also, they have a very threadbare agents department at the moment to be able to field and answer those questions. However, I have conferred with one person involved in such a case. The result was appealed, and the exam result was reversed from a fail to a pass. But for me, this is a ludicrous situation. A computer-based, multiple choice, 20-question exam, which you would presume is marked automatically. Thus, marking answers wrong, which are in fact correct, is to me inexcusable. Added to that, I am informed that candidates were only given 5 days to appeal after receiving their result, and information on which questions they got as incorrect. And the onus was seemingly on the candidate to prove the marking was incorrect. But as I said, we don't know how many were affected by this or how many questions this relates to. Plus, not just those who were wrongly marked as a fail, how many may have been marked as a pass when they possibly shouldn't have? And ultimately, for me, that's another matter that does bring into question the integrity of the exam, the licence, and FFAR as a whole, albeit not on the scale of the debacle of Birmingham for the first exam sitting in England. If it wasn't so potentially damaging for people and so serious, it may just be considered ridiculously funny.
Yeah, I saw FIFA announce an appeal process for this. That's a good thing. Also saw a lot of lawyers, especially on LinkedIn and also WhatsApp groups, that they wanted to take on any failed examinees who got a close passing mark to reach out to them so they can contact FIFA. So there was a process in place. You did have 5 days, but the agent chatosphere, if I can call it that, went hot with this. And a lot of examinees were onto it, especially if they thought they had some questions they answered correctly and they were marked wrong and they were so close to a pass mark. But very interesting situation for this, because as you say, Jonathan, knowing that you probably could have passed and a mistake was made or a mark was missed is a brutal blow to someone entering the business of football agency. So we want to see transparency, we want to see fairness, and we also want to see natural justice for people who worked hard and may have, due to a technology issue or something, missed out. So very important. But now, Jonathan, it's quick takes time. Quick takes, not quick picks, not quick clicks. It's quick takes. I'm not saying this is my favorite part of the podcast, but we always find very interesting stories. So quick take number 1, New Balance's Rich Paul. What is unique about the sports agents collaboration with New Balance? That's a title headline. Rich Paul, one of the big agents in the USA, is probably more popular than a lot of athletes, one of the most celebrated agents in the league, and he's developed a personal brand alongside the success of his company, Clutch Sports Group. And believe it or not, and we see with players and we see with major sports, that brands, especially the apparel or the sneaker brands, collaborate, sponsor, endorse athletes. But here, collaboration between an agent with New Balance has seen the rise of Paul's popularity. In 2023, New Balance collaborated with Rich Paul in launching a colorway for the latter in their most popular shoes, the 550s. So very interesting collaboration. And we have mentioned this in podcasts before, Jonathan, that football directors and agents are now can be the stars of the show. And this is coming from the US, of course, but this is an example of an agent really superseding a lot of people and becoming the brand.
I think we've got a lot of famous agents in the football world. And despite them thinking that they're a brand in themselves, I think there's very few who can claim to be that. I can think the late Mino Raiola might have been along those lines, and Jorge Mendes. But some of the US agents take it to a whole new level. And when we do the research for the show and we get feeds on sports agents and that, there's usually 2 names crop up. One is Scott Boras, who's a US agent. But the name that crops up most is Rich Paul. He's got a phenomenal brand. Also, it helps that he's in a relationship with a superstar pop star, but his brand is phenomenal. And I think despite some football agents thinking they are a brand in themselves, as in soccer agents, I think everybody is a long way behind establishing a brand along the same lines as Rich Paul and getting such brand awareness from their name.
And speaking of Rich Paul, quick take 2. And this just came in the other day. The United Talent Agency, which is a huge American talent agency, acquired one of Germany's biggest football agencies, RUF, otherwise known as Representative of Outstanding Footballers. I love that name. What they've done is they're integrating Roof with Rich Paul's company Clutch Sports Group to reimagine the landscape of representation in football. Roof is based in Munich, over 150 clients across the 5 big leagues and beyond in Europe. So a huge agency, and it's another merger and acquisition. It seems like all the big American talent agencies have bought the bigger agencies in England and now in Germany.
We've seen a growth of these, what are being termed now, I believe, as MAGs, multi-agency groups. And there's a number of theories about why it's happening and what's steering it, but it's going to have a phenomenal impact on the market. And I think it's a strategy that's just going to grow and grow. Whether it'll be good, we don't know.
Yeah, I think there's going to be a lot more happening in that space, in the talent space, and considering the way the FFAR is also going in terms of football services, but other services as well. Quick take 3 is the Ghana Football Association wishes to congratulate all candidates who were successful in the recent FIFA player agents license examinations held at the Ghana Football Association headquarters. This is on their website. It's a media release congratulating successful candidates, wishing them fulfilling careers as FIFA accredited player agents. It also mentions there was a sizable turnout of applicants, and this is the interesting part for me, that interest in the business of football player agency remains strong amongst Ghanaian football enthusiasts. And I like the fact that this FA wishing people well. It's a very nice touch by the Ghanaian Federation. I'm going to move on to quick take 4. It's the All India Football Federation, which also successfully conducted their FIFA football agent license in New Delhi. An interesting one here is it was 37 candidates, including 2 overseas aspirants flying to New Delhi. And that's an interesting take there because a lot of agents are going to other countries to take the exam. Now, we know also FIFA has talked about helping, I would say, national federations set up the FIFA football agent exams. And countries like, I mentioned India, but Andorra, Haiti, the Gambia also recently held exams with FIFA's assistant. Is FIFA really trying to drive the agent business worldwide here? This is an important part of the business.
Yeah, this was in relation to the Inside FIFA newsletter, which is periodically released. And this one was the 3rd of June on FIFA member associations in focus and the May 24 newsletter. And as you mentioned, they referenced the Gambia, India, Andorra, and Haiti. But it was the other wording in the article that caught my eye. And that was, and I'll quote from FIFA's newsletter here, FIFA's investment captures a wide range of groups within the football family, including football agents. So we're part of the football family. It's very important to consider that when the question comes up whether agents are stakeholders or participants and the involvement they have in any consultation on such matters, dare I say, as FFAR.
Yes, very interesting choice of words. Football family, we haven't heard stakeholders, but football family, very interesting and maybe a step in the right direction. Quick take 5, and there's an article that was published, and I'll read the title. The day the Wembley tax haven closes in North London, it looks like the Mbappe tax law will get a run out at the Bernabeu. The Bernabeu being the Real Madrid stadium. And this interesting take is that what's happening in Madrid. A cut in the income tax rate to 24% is available, provided certain conditions are met for foreign workers, including footballers, who carry out their work in the Madrid region. So Mbappe, we know, joining Real Madrid, but player who joins Atletico Madrid, Getafe, Rayo Vallecano as a player and a coach, this tax cut will benefit you. We've seen this in Italy before, that they had a bit of a tax cut. We had the Beckham law also, where certain individuals were treated as non-resident for 6 years previously in Spain. So that's a very interesting that tax, and this is just Madrid, not whole of Spain, able to attract players of the caliber of Mbappe, Galacticos, if I can call it that, with the tax law, which we've seen in a few countries, Jonathan. Now, the final quick take is one that I think I'll need your input, Jonathan. It's the Premier League clubs won't vote on salary cap anchoring idea at the AGM amid opposition from the PFA. And this is a New York Times article in The Athletic as well, because they cross-syndicate. The Premier League will not put its controversial anchoring proposal to a vote at its annual general meeting on Thursday after the Professional Football Association made it clear it would fight the cost control measure. The aim of the anchoring was to limit the amount a club would spend on its first team squad in the EPL, the English Premier League, to 5 times the amount of the bottom place team receives from the league in centralised media and sponsorship income. however, may not get off the ground.
I think this story is one for everybody to keep an eye on, not just the agents. And in terms of cost controls and anchoring, because anchoring is just one part of profits and sustainability and the cost controls. And anchoring, from what we understand, and we discussed it with Kieran Maguire on a previous episode, it's going to have a huge impact on agents because it's not quite clear how it's going to apply to agents and whether it's going to be consistent. And this delay on the vote is primarily because of this PFA challenge. And it's sort of sent shockwaves through the Premier League because they've got all these legal challenges coming up. They have Man City taking legal action against the Premier League with regards to related parties, which has also affected the timeline for cost controls. And in the last 24 to 48 hours at the time we're recording, there are reports of Premier League club owners stating his club, Aston Villa, are potentially following a similar path to Manchester City with a legal challenge to the Premier League. So the Premier League have all these potential challenges lining up. It's a bit like the queue for FIFA challenges at the ECJ at the moment. It's getting longer and longer. But back to the PFA's objections. The PFA does seemingly have one of the most prolific English football barristers in their corner once again, Nick DeMarco, who helped them defeat a proposed cap on player salaries in England not too long ago, albeit that was on somewhat of a technicality. And just worth making people aware, Nick has his own sports law podcast for anyone interested in the heavier legal topics surrounding football and sports law. But the other thing from this story regarding the PFA and the Premier League that we need to be mindful of is the importance of CBAs in such situations, collective bargaining agreements. Something the players have through the likes of the PFA and FIFA, but as agents, we don't have such protection. Although there are rumours of memorandums of understanding, MOUs, being proposed by FIFA to some agents or agent groups, but not CBAs. Both of which I think are going to be difficult to establish or even be seen as legitimate, given the ongoing disputes over FFAR between FIFA and many of the agents. Plus, there's the fractured nature of the agents industry as it stands.
We have obviously collective bargaining agreements in Australia in terms of the A-League, of the clubs and the players, but no protection for the agent industries at all. Hopefully the agent associations can create better framework for agents and to get more unity and protections for our business. As you mentioned, we are quite fractured as an industry. There's got to be some protections for the industry because just looking at the number of people involved, it's pretty much everyone left their own devices unless obviously you're part of a big agency. So we have to look at these sort of issues, protections, fair competition, and the ability to do your work and get paid for it without having nowhere to go, nowhere to dispute anything. So this is where the agent associations also got to get on the front foot, Jonathan.
And on that point, that brings us to the close of this episode of The Agent's Angle. We hope that by answering some of your questions today, that will prompt a few more people to send appropriate questions in on matters related to football or soccer in the agent's world, as well as requests for guests and topics you would like to hear on the show. And on the subject of guests, we have just recorded 2 new guest interviews, which will bring you over the next 2 episodes, all being well. And for me, I think those guests have been amongst the most interesting so far, although they are very different, so something to look forward to. As such, we are putting back our summer break by 1 week to bring you those interviews. So on that point, for now, it's bye from me.
Yes, there's always a lot of stories in the agent business, and with this transfer window, I wish everyone the best, but there'll be a lot of news coming up. So it's bye from me and take care.
The purpose of the Agent's Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.